So fantastic to see so many people coming out on a Wednesday night to be part of this conversation. First, I'd like to start by acknowledging that we're meeting on the stolen and still occupied land of the Wurundjeri Woiwurrung people, and I also acknowledge their legal claim for recognition of native title, just filed for recognition of native title under an imposed colonial legal system. I pay my respects to their elders and to any and all First Nations people who may be here tonight. I also think it's appropriate in the context of acknowledging the country that we're on to acknowledge the conclusion of the first treaty process here in Victoria, as well as the conclusion of the Europe Justice Commission's truth-telling process. And given the focus of tonight's discussion, I think it's also incumbent upon all of us, particularly those of us who are lawyers, to acknowledge the role that the law has played in both the dispossession and occupations and continued harm, but also slowly and piece by piece, some measure of redress and accountability, which is really hopefully what brings us all together in terms of looking at the issues under discussion tonight. It always was and always will be Aboriginal land. So the format tonight for this public lecture, we will have two presentations by our esteemed guests here tonight, followed by some time for questions and answers. You are very welcome, you don't have to wait till the end, to scan the QR code and start putting questions into the system. We're using the Mentimeter system, and that's really aimed to make sure that we get as many questions as possible. So please scan the code, add the questions in. You're really welcome to specify and direct a question to either Emily or Chris or leave it open up to you. And there's a wonderful team of moderators who will be helping pass them through to me, hopefully seamlessly by the end. This was a sold-out event tonight. I think there's some people still coming in, but so that everybody can be fully present and out of respect for our speakers, please do put your phones onto silent or turn them off. If you do, for any reason, need to take an urgent call, please step outside. I'd like to also thank the sponsors and organisers of tonight's event. First of all, the Association for the Promotion of International Law, the Australian National University, the International Commission of Jurists, and Amnesty International Australia. Amnesty also has a table outside, and there's a couple of petitions that people are all welcomed to go and have a look at and sign up to, and I believe you turn left outside as opposed to going out the front door. So to move on to what you've all come here to hear, we have two incredible speakers. First of all, we have Professor Emily Crawford. Emily is an internationally recognised expert in international law at Sydney Law School, where she's also Deputy Dean. She specialises in international humanitarian and criminal law, and in 2023 she was awarded the Max Planck Cambridge Prize for International Law for her outstanding research contributions. Emily, over to you.
Thank you. So obviously it's been a monumental few months for international law and international lawyers. Most recently we've seen the United Nations Security Council voting through the Gaza Authority Plan. But what I want to discuss is the infrastructure that has played a role in facilitating not just the conflict in Gaza, but is increasingly facilitating conflicts all around the world. So I'm going to be talking to you tonight with a specific focus on Gaza about the increasing role that corporations play in sustaining armed conflict and what international law and what we can do to respond, because frequently, my students despair of the ability of individuals to affect change, especially when you're dealing with international law, when you're dealing with sovereign nations. And it's often in the case where people power in terms of things like boycotts really can play a role. But I should note from the start that this is not a new topic. Corporations have been involved in armed conflict for decades, if not centuries, from profiting from the chaos caused by armed conflict to providing the material necessary for the execution of the military objectives of the parties involved. In fact, if you go all the way back to one of the earliest documents of the law of armed conflict, the 1863 Lieber Code that was adopted during the American Civil War, there is a specific reference to persons who accompany the armed conflict, the armies in the field, known as sutlers. Sutlers being civilian merchants who sold provisions to the army when in the field to supplement what they already had. And that's not even before we get into the long history of sovereign states engaging armies for hire or mercenaries to assist them in fighting their wars. And likewise, the role of private paid actors has been the focus of renewed attention in the last 10 to 20 years, following the widespread use of private military and security contractors in Iraq from 2002 onwards, and more recently through the deployment of the Wagner Group in Africa and in Ukraine. So it's not new territory to query the role of private commercial actors who profit from the chaos of armed conflict, and to ask whether international law could play a better or more expansive role in regulating commercial actors. And there have been steps to do so in some of the landmark documents of international law, Additional Protocol 1, later followed by the Mercenaries Convention. There is an international prohibition on the use of mercenaries in armed conflict. And this was followed by work done by civil society organisations in the 2000s to adopt non-binding documents outlining kind of best practice for if private security corporations are employed in situations of conflict or otherwise unstable environments. So there is international law on the issue, but where there is a gap in the law, both internationally and to some extent domestically, is when you have situations of corporate involvement in armed conflict where it doesn't amount to direct participation. So in international humanitarian law, law of armed conflict, the idea of direct participation is, I'm going to grossly simplify, fairly simple. You pick up a gun, you fire it, you're considered to be directly participating in hostilities, and you can be targeted for that direct participation. Under the law, that level of causation and connection is reasonably straightforward. But the law of armed conflict in international law has very little to say about corporate involvement in armed conflict when it's not so direct, when it's not about picking up a weapon, because direct participation is largely about causal proximity to the eventual harm. Fire the weapon, launch the missile, plant the landmine. Someone is injured or killed, there's that direct causal link. But step back 1 degree, manufacture the missile, construct the parts of the weapon, and IHL generally doesn't consider that to be participation that is sufficiently causally linked, even though there is that clear connection. So a weapons manufacturing plant would be considered a legitimate target in a conflict, but the people who work in the plant would still be considered civilians. And even more remote and even further removed from the law of armed conflict is when corporations take advantage of and even support an armed conflict for financial benefit. There is no rule under the law of armed conflict that prohibits war profiteering, again, unless it gets to the level of direct participation or otherwise breaches international law. And I wanted to set the background for this because tonight I'm going to do a close read of a report that came out in July of this year by the Special Rapporteur on the Occupied Territories, Francesca Albanese, about what she calls the economy of genocide. Now, I first need to make the disclaimer for any international lawyers in the audience. Under international law, war and genocide are not coterminous. You do not need to have the existence of a war for there to be a proven genocide. But as we have seen in Israel and in the occupied territories, the armed conflict, such that it is, even though there is purportedly a ceasefire, and the genocide have been taking place side by side. And indeed, the genocide has been facilitated by the outbreak of hostilities following the October 7 attacks. So with that legal disclaimer out of the way, I'm going to delve a little bit into Francesca Albanese's report because it's really important for us all to know, because as much as we believe that we are not supporting what's taking place, corporate involvement has meant that it is almost inescapable. So the core of Albanese's report is in its tracking of the metamorphosis, or perhaps even the continuation, of Israel's war economy from one of occupation to one of genocide. Essentially, Albanese explores how historically Israel has exploited Palestinian labour and resources, both through the use of Palestinian land for Israeli enterprises, and then through the positioning of the Palestinian people as a captive market for Israeli commerce. So Israeli regimes have displaced and dispossessed Palestinian populations and then sold that dispossession back to them through, for instance, monopolies on water and electricity in occupied territories. And so Albanese looks at this long-standing system of dispossession and exploitation, and she says it's crucial to understand it because it's what set the groundwork for how very quickly crimes against humanity and genocide were able to be carried out following the October 7 attacks. Because as much as the terminology around the October 7 attacks was it came out of nowhere and no one knew it was going to happen and they were so shocked and it was kind of seismic event, the Israeli war mechanism turned into place very, very quickly to carry out these significant attacks, and could do so because of decades of commercial infrastructure that allowed them to do so. So the Albanese highlights that Israel had intentionally created Palestinian dependency on its infrastructure for essential resources such as water, electricity and fuel, and so therefore the cutting off of these supplies was something that then could facilitate their activities very, very quickly. And it's presented not merely as a military tactic, but as an act that clearly meets the legal definition in Article 2 of the Genocide Convention, that of deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Now, Albanese makes the case that it is and was the deep connection between the infrastructure of the occupied territories and of Israeli control of such infrastructure that made the post-October 7 atrocities so quick to implement. That basically it was very easy to repurpose the infrastructure in the occupation environment to be a weapon of war and as a tool to violate international law. And her report really makes the case that the situation in Israel forces us to think more deeply about corporate involvement in armed conflict, not just in Gaza, but around the world, because it is a tool that can be very, very quickly weaponized, as much as late-stage capitalism likes to tell us that it is neutral, that its only driver is economic. So to contextualise, a weapons manufacturer, a Lockheed Martin or a Thales, could theoretically argue that their very existence is prima facie compliant with international law, that sure, they manufacture weapons, but they don't manufacture weapons that are currently prohibited under international law. So international law has treaties that say you can't produce chemical weapons, you can't produce biological weapons, you can't produce blinding laser weapons and things like that. And Lockheed Martin or Thales would say, well, we don't do that. We manufacture weapons that are currently not prohibited under international law, so therefore we're not violating international law. And they go further to say, look, it's not on us that the F-35 that we sell to a state government is then used to breach the law of armed conflict. That's on the state. We're not connected to that. And international law roughly kind of takes that position. Complicity lies with the state that carries out the act and not the manufacturer that gave them the means to carry out such an act. And this kind of reasoning underpins current international law weapons reviews, which basically looks at whether a weapon will be prohibited not because of its potential use, but whether it is inherently a prohibition of international law, if it's inherently of a nature to cause superfluous injury or unnecessary suffering. But Albanese's report quite rightly points out that such disclaimers notwithstanding, the situation of corporate involvement in Israel is, in particular, cannot be assessed in a vacuum, that the long-standing and well-established and well-documented systematic oppression and restrictions placed on the occupied territories and the well-established legal principles that had been outlined by the International Court of Justice in the advisory opinion on the wall and the much more recent advisory opinion on the obligations of third states in the occupied territories, makes it currently impossible for any corporation to engage in any kind of dismissal of causation or proximity to acts that are taking place in the OPT. That any corporation that, for instance, sells land moving equipment like tractors and earth movers to the Israeli government must know that they will likely be used for the demolition of houses in the West Bank. So what Albanese is arguing for is a much broader scope of what constitutes complicity and a greater understanding and appreciation of heightened human rights due diligence on a much wider range of corporate actors. So in her report, she goes through and she presents a detailed and extensive mapping of corporate involvement and categorises named companies by their respective sectors and detailing the specific allegations against them. And it's sobering reading because there would not be one company that I'm about to name that we haven't all engaged with probably today. So in terms of technology and surveillance, the report details the deep entanglement of US technology giants with Israel's military and surveillance apparatus. Companies like Microsoft, Google and Amazon provide cloud and AI infrastructure under Israel's $1.2 billion Project Nimbus, which basically entirely facilitates the state surveillance and military targeting that the Israeli government carries out. In terms of arms and heavy machinery, Caterpillar, Hyundai and Volvo have supplied heavy machinery, including the D9 bulldozer, used in the systematic destruction of Palestinian homes, infrastructure and farmland. And the report notes that the equipment, which is obviously often categorised as civilian, has become a militarised tool of destruction. And this is on top of the obvious connections to military organisations and manufacturers like Lockheed Martin and Elbit Systems. In terms of financial investment institutions, global financial actors are central enablers of the settler colonial project. Major insurers and investors like Allianz and AXA are named for their extensive investments in companies linked to the occupation. In posing what international law can do in response, Albanese points out that we really only have kind of one document that's specifically on topic, the UN Guiding Principles on Business and Human Rights. It's a normative guide. Now, the problem is it's not binding. So you don't breach the guiding principles, you just have not followed them. But the guiding principles are what we have, and they're not without some normative force. It states that companies operating in conflict-affected contexts have a heightened obligation to conduct human rights due diligence to identify, prevent and mitigate risks of their activities contributing to human rights abuses. And this framework places responsibility on corporations, not just to avoid causing harm directly, but to also prevent their activities from being directly linked with or contributing to adverse human rights impacts. But Albanese goes further, and this is where I think there is a real kernel of hope for us to actually be able to start holding states and corporations accountable, which is she employs the international criminal law principle of joint criminal enterprise, arguing that corporate involvement is not just a passive act, but it is an act of collaboration. And in its framework, the acts of a single actor, such as a corporation supplying a piece of equipment, contribute to a large system of international crimes. And so this legal interpretation positions corporations as active participants rather than mere bystanders. And to support this contention, Albanese actually goes back to the trials that took place in Germany after the Second World War, specifically the prosecution of IG Farben, the German industrial conglomerate that was the largest industrial supporter of the Nazi regime, and which in the aftermath of the war was prosecuted for having manufactured and supplied Zyklon B to the Nazi death camps. And in that case, one of the three against German industrialists, including the Flick and the Krupp trial, the Allied Control Council held that both individual executives and the corporate entity were to be held accountable, and in the IG Farben case, ordered the company's dissolution, although Krupp still exists in its current form through its merger with Thyssen. So the report concludes with a series of recommendations intended to dismantle the economy of genocide, and the most prominent of these is, of course, a call for a comprehensive two-way arms embargo on Israel. And this recommendation goes beyond the actions of countries that have only suspended arms trade and arms sales, instead demanding that it should be both arms exports to and from Israel, as well as sanctions on all other kinds of exports and imports. And it's framed not just as a policy choice, but as a legal and moral obligation under international law to prevent genocide. Because Albanese urges state and companies to promptly cease all business activities and terminate relationships that contribute to human rights violations and international crimes. It calls for sanctions and for a full arms embargo with the goal of isolating Israel economically. And she further demands that national and international legal institutions investigate and prosecute corporate executives and entities implicated in international crimes. Now, unsurprisingly, when she released this report, it came in for significant criticism for points which to an international lawyer seem obvious, but to someone who perhaps doesn't know the nuances might seem like they were the slam dunk. So one of the obvious allegations they made against her was, well, she's referring to the UN Guiding Principles on Business and Human Rights. It's not binding. So what's she doing? Somehow this rendered the entire report deeply flawed, whereas international lawyers understand that normative principles such as treaties often sit alongside non-binding instruments and can be as effective, if not in some cases more effective. And Albanese certainly came under a huge amount of criticism and has been specifically targeted and sanctioned by the US government, which is practically unheard of in the history of the UN that someone has specifically come against her with such vehemence, when you especially consider that as a representative of the UN, she has diplomatic immunity. These critiques are, in my opinion, at best one-sided, engaging in a huge amount of what we see in what goes for public debate at the moment, whataboutism. At worst, they're spurious and malicious attacks with little basis in sound reasoning. So I'm going to wrap things up there because I'm going to hand over to Chris to kind of follow up and talk a little bit about what we as Australians can do to kind of confront this and engage in this in a more meaningful way, such that we might be able to affect some change. Because when we had this event in Canberra a month ago, basically one of the first questions that came up was, what on earth could we possibly do to fight against this? And my wholly unsatisfactory answer was, you have to keep pushing. To do nothing is to give in to nihilism, and nihilism allows the other side to win. And while boycotting an institution might not feel particularly powerful when it's just one person, I think, and again, pardon me for an extremely poor analogy, but we saw what happened very, very quickly when enough people started cancelling Disney Plus subscriptions following the removal of Jimmy Kimmel from the air after attacks by the Trump administration. So we are not without power. We just have to be able to exercise it collectively. So I'm going to hand over to Chris to continue our discussion.
Thank you, Emily. Quick introduction for those who do not already know of Chris Sidoti's eminent career. He's a leading human rights advocate and legal expert. He served as Australia's Human Rights Commissioner. He served as an Australian Law Reform Commissioner and was the founding director of the Australian Human Rights and Equal Opportunity Commission. Internationally, he has also gone on to play a leading role in many of the human rights investigative processes that have been set up in recent years. He was a member of the UN fact-finding mission on Myanmar and was, until recently, a commissioner on the UN independent inquiry into the occupied Palestinian territory, including East Jerusalem and Israel. So, Chris, over to you to hear a bit more about the Commission's work.
Thanks, Caitlin. Thanks, Emily. I too start by acknowledging the traditional owners of the land on which we meet, and particularly acknowledge how well they have cared for this land and handed on to us to share it with us at this time. The sponsors tonight are all organisations with a strong commitment to international law. That is the basis of their work as organisations, and it's been the basis of my work as an individual. In promoting international law, we are really promoting good international citizenship. And the question that confronts us today is whether Australia wants to be a good international citizen, observing international law. I assume that we do, though there is some doubt about that. Do we, as Australians, want Australia to be a good international citizen, observing international law? The fact that we're all here tonight indicates that we do. So the focus of my comments, as Emily's indicated, will be very much about the obligations that we have as a state, Australia and all of its constituent parts, because international law concerns states and territories as much as it does the national government. So Australia, and what we as individuals can do to promote international law in the current circumstances as well. International law is the law of and concerning states that is binding on states. But it also extends to individuals. Indeed, one of the most significant developments of international law over the last century or two, from its origin centuries before that, has been the extension of the concept of law from states alone to individuals as well. So under international law, individuals have responsibilities in war and later in armed conflicts generally. And individuals also have rights against their own states and against other states, and also as against each other. So it's no longer possible to speak of international law only as a law binding states, although states are the principal actors under international law. In my work over a very long time, Caitlin described some of the things I've done. Now, when you get to be as old as I am, you wind up having done quite a few things. But my work internationally and domestically has depended entirely on international law. It certainly was the case when I was Australian Human Rights Commissioner. At the national level in Australia, we have no constitutional or statutory Bill of Rights. And the only things we have to rely on for human rights at the national level is international law, the human rights treaties that we have ratified. And so the Human Rights Commission legislation can't refer to a Bill of Rights, it can only refer to international treaties. That's not the case in Victoria now. As an NGO advocate in Australia and internationally, my advocacy has always been focused on international law. And as a UN investigator in the two areas that Caitlin mentioned, dealing with Myanmar and then with Palestine and Israel, the basis of the work has been international law. So I have had to deal with international law not as an academic. I don't have the depth of knowledge that Emily has, for example. I've dealt with it as a practitioner, an international legal practitioner seeking to apply it and to tease out its implications. The UN investigations have been investigations into factual situations. The starting point has been the collection of evidence. And then on the basis of the evidence, forming conclusions of fact. And then applying to those conclusions of fact relevant international law. And so forming legal conclusions and making recommendations. This is standard legal methodology. Collecting evidence, finding fact, applying the law. And that's all that we've done. For 2 years, I worked on the fact-finding mission on Myanmar, basically a commission of inquiry under another name. And during those 2 years, we undertook detailed investigation. In the first year, we conducted in-person interviews with over 800 Rohingya people who had fled from Rakhine State in Myanmar. By the end of the 18 months, when we were down to writing reports, we had conducted interviews with 1,450 victims and witnesses, as well as collecting information from other sources. So these investigations are quite intensive work. During the course of 2 years, we produced 2 reports, 5 supplementary reports, totaling almost 900 pages in all. That's the kind of work that human rights investigations do. We made findings of war crimes and crimes against humanity and recommendations for investigation and prosecution of named individuals, including for the crime of genocide. So when I came in 2021 to be appointed to the Commission of Inquiry dealing with Palestine and Israel, I came to it having had that experience in Myanmar. It's interesting, just as a side comment, that I didn't cop much criticism for doing the investigation of Myanmar, even though essentially it was exactly the same work as I'm doing in relation to Palestine and Israel. But that's just an aside. The Commission of Inquiry on Palestine and Israel was established in May 2021. It was established in the course of Human Rights Council consideration of that month's episode of the 100-year war concerning Palestine and Israel. It didn't come directly out of 7 October 2023. In the same way as 7 October 2023 did not, in the words of the UN Secretary General, occur in a vacuum. It is dealing with a war that has been going on now for almost a century. And we came out of the episode that occurred in May 2021. We started our reporting in June 2022. Our first reports to the Human Rights Council were produced then. And between June 2022 and September 2025, a bit over 2 years, we produced 8 reports, 5 supplementary reports, 2 legal policy papers, 15 reports in all, which I think is pretty good in 2.5 years. And we made findings of war crimes, crimes against humanity, and the crime of genocide, and made recommendations for investigation and prosecution, both of individuals named in our reports and individuals not named in our reports, but provided to the International Criminal Court. The findings of war crimes have had general application. Before October 2023, we found that Hamas and Islamic Jihad had been committing war crimes by randomly firing rockets into Israeli population centres. And we also found war crimes in the conduct of the Israeli security forces in the West Bank and Gaza. Similarly, one of our first reports dealt with the Hamas and Palestinian Islamic Jihad attacks in southern Israel on 7 October 2023. We, in fact, have reported more comprehensively on what happened on that day and the following day in southern Israel than has the Israeli government or the Israeli military forces, far more comprehensively. We are prepared to issue public fact-finding results and to make findings in relation to war crimes. We have also found war crimes, crimes against humanity, and the crime of genocide have been committed by the Israeli forces. Let me just say a little bit about the crime of genocide, because the crime of genocide is the most difficult to establish in international law. War crimes relates to the conduct of individuals, and they can occur on a very individual basis. You can have a war crime that is committed by one individual on one occasion in one situation. Crimes against humanity extend beyond that. They require systematic and widespread commissions of acts that collectively constitute a crime against humanity. Genocide requires a much more comprehensive examination and determination. And that's why it took us 2 years before we issued our report on genocide. 2 years of fact-finding in other areas. Our reports over that period, reports of investigations into specific aspects of this conflict, were needed to collectively examine the question of whether the situation as a whole, the method of operations, the strategies that were being employed, constituted the crime of genocide. Genocide, like all crimes, requires both a factual element and an element of intent. That applies to crimes under our domestic law and to crimes at international law. For genocide, there are 5 categories of international genocidal acts. And we found that 4 out of those 5 had been committed in Gaza since 7 October 2023. And we made that finding on the basis of the reports that we had prepared. Reports that examined the destruction of health infrastructure and the targeting of health and medical personnel, the destruction of educational infrastructure and the deprivation of schooling for 1 million Palestinian children in Gaza over a 2-year period, the destruction of cultural sites, including churches, mosques, museums, archaeological sites, libraries, the sex and gender-based violence that was occurring, the destruction of housing, the clearance of land. These are elements that we looked at specifically in different reports during the two-year period before we came to consideration of the question of genocide. And we found that 4 out of the 5 categories of genocidal act had been committed. The intent side has 2 elements. Intention to commit the particular acts, that's fairly standard. It's necessary that these things occur intentionally or recklessly, not accidentally, for example. But there is a second element of intent relating to genocide that is quite specific to genocide. And that is the intent, the purpose of committing these acts for the destruction of a designated group, designated by race, ethnicity, nationality, or religion, and then the intention to destroy the group in whole or in part. Note in part. It's not entire destruction of the group that is required before genocide can be established. Partial destruction also falls within the definition. So we found genocide in Gaza based on our own investigations, which had been reported progressively over a period of 13 months, based on the facts that we found, and then the application of the law to the facts. Our findings have obvious implications for the combatants, those directly involved in the fighting. So the State of Israel and its officials, soldiers, agents, the State of Palestine and the armed groups operating within the umbrella of the Palestinian struggle. All of them are required to observe international law. And so our findings related clearly to them. But our findings and international law itself also have clear implications and impose obligations on states other than the combatant states, so states other than Israel and Palestine. What we found and what we have reported has direct implications for third states, and our reports often include recommendations to third states. And Australia is a third state. So our findings have direct implications for this country and our international legal obligations. These obligations arise under treaties. The Genocide Convention requires not only that states not commit genocide, but that states also prevent genocide and punish genocide where it has occurred. Genocide is a crime under international law, and state parties to the convention, including Australia, have an obligation to prevent and punish the crime of genocide. Under the Geneva Conventions, the conventions that govern the law of war and of armed conflict, there is an obligation not only for the state itself to respect the Geneva Conventions, but also to ensure that other states respect the Geneva Conventions. And so there too, third states, like Australia, have obligations to ensure that other states meet, respect the provisions of the Geneva Conventions themselves. The International Court of Justice has specifically recognised the obligations of third states. And in its most significant decisions relating to the conflict in Israel and Palestine, they have referred specifically to the obligations of third states. When they found, for example, the International Court of Justice, that the occupation was unlawful, that settlements were unlawful, and that the State of Israel owed reparations to the Palestinians who were the victims of its unlawful conduct, the court spent some time dealing with the obligations of third states under this situation. It dealt with these obligations under a broad general statement. third states have an obligation not to aid or assist the continuation of Israel's unlawful acts. So not to aid or assist the continuation of the unlawful occupation, of the unlawful settlements, or the failure to provide reparations and to respect the rights of the Palestinian people. Not to aid or assist in any way. And the court was very helpful in indicating broad areas in which this obligation needed to be met. It referred to political and diplomatic, military, economic and financial, cultural sectors. And it gave a number of examples. So third states, including Australia, have obligations under international law, both treaty law and customary law, to ensure that Israel and Palestine comply with the Geneva Conventions and also obligations to prevent and punish the crime of genocide. Early in October, the President of the United States released a 20-point thought bubble. It contained some very important elements. 3 of them were agreed by the parties, only 3. And that is that there should be a ceasefire, that Israeli hostages and Palestinian prisoners and detainees should be released, living or dead, and that humanitarian aid should be allowed at scale, at a sufficient level to sustain life into Gaza. So 3 points, 3 very important points were agreed, but none of the other 17. And those 3 points, we can say, have been largely observed, but certainly not wholly. There have continued to be Israeli attacks that have caused the deaths of Gazans on a daily basis. Humanitarian aid at this stage is going in at barely a third of the level that had been agreed under the 20-point thought bubble. There's been release of hostages. At this stage, last I heard, only 4 bodies of Israelis had not been returned, and the Israelis were meeting their side of the agreement by releasing Palestinian detainees and prisoners in the numbers that had been agreed. So that one has been almost entirely observed. The other 2 are being largely observed. My fear at the moment is that this agreement, which was not an agreement really, this thought bubble, which now has some characteristics of law because of a decision taken on Monday by the Security Council, this thought bubble will be responded to by states and by communities as having resolved the situation, and that we can forget about all of our responsibilities now. The end of a conflict does not wipe away sin, even when the conflict has actually ended. Responsibility for war crimes, crimes against humanity, and the crime of genocide continues. Violations of international law committed in the course of the conflict remain violations for which the perpetrators should be held accountable. The obligation to punish continues beyond the end of the conflict, and the obligation to prevent continues as well. The nature of a conflict can give rise to real, continuing, reasonable risks that in any renewal of the conflict or in any future conflict, a state will again pursue policies and practices that violate international law. And so in terms of the Genocide Convention, the obligation to prevent is a continuing obligation. So did I say genocide? The Genocide Convention. In terms of the Geneva Conventions, the obligation to ensure respect is a continuing obligation that persists whether the conflict has ended or not. So the facts on the ground in Gaza and the continuing repression in the West Bank, let's not forget the West Bank, indicate that the conflict may not be over, that the ceasefire is very fragile, that it continues to result in civilian deaths every day, and that therefore the obligations of third states persist. The International Court of Justice has called for action, as I said, in political, diplomatic, military, economic and financial and cultural spheres. Australia has already done much in relation to this conflict. Even before 7 October 2023, we had prohibited the export of weapons. The Prime Minister and the Foreign Minister constantly remind us when asked what they were doing. But they give that one answer. We have also imposed sanctions on 2 Israeli ministers, Ben-Gvir and Smotrich, and some criminal settler leaders. We have changed our voting patterns in the General Assembly to be more critical of Israel and more supportive of Palestine. We have recognised the state of Palestine. These are all good moves that are consistent with our obligations under international law, but they're hardly sufficient. Australia must do more, not for political reasons. I'm not a politician and I'm not going to tell them what to do politically. I'm a lawyer. Australia must do more for legal reasons. And so I want to give you my 20-point thought bubble for Australia. 1, in accordance with the International Court of Justice advisory opinion, we must commence by undertaking a comprehensive, urgent review of all Australian connections and dealings with the State of Israel to identify those aspects of the relationship that do or could render aid or assistance in maintaining the situation created by Israelis' unlawful occupation and its promotion of unlawful settlements. And we must cease all those areas of the relationship that do aid and assist Israel's unlawful activity. Now, I would have expected that to have been done immediately after the International Court of Justice in July 2024 said what it said. And the fact that we didn't do it already raises questions about our interest in being a good international citizen. 2, we should end political and diplomatic visits and exchanges with the State of Israel. I'm not suggesting that we have to withdraw our ambassador or close our embassy, but I am saying that the visits that parliamentarians make or ministers make should not continue, and that the kind of exchanges of a political nature with the State of Israel should be suspended. 3, we should cease all military-related trade. And this is more than the Prime Minister and the Foreign Minister's concern about the export of weapons. I accept that. That's a great idea. But the export of weapons is not the only issue related to military-related trade. There is also the export of components made in Australia. And we know that Australian-made components are going into F-35 jets, and we know that F-35 jets have played a critical role in the Israeli total bombardment and destruction of Gaza and all of Gaza's infrastructure. We can't hide behind supplier relationships in allowing Australian components to be used for military purpose by the Israeli military in Gaza. And trade is a two-way thing. It's not just about weapons exports. It's also about what we buy from the State of Israel. And in particular, surveillance technology, which is trialled on Palestinians. And that's why it's amongst the best in the world, because it's trialled so extensively in battle situations. Australian police forces, the Australian military, should not be importing surveillance technology from the State of Israel, principally from the Israeli arms company Elbit, which is the main private sector armament company supplying the Israeli military. So arms trade means all military-related trade two-way. 4, we should cease military trade promotion, such as the exhibition held in Sydney 2 weeks ago that was co-sponsored by the Department of Defence and the Australian Navy and featured exhibitions by Elbit again and the Israeli state company Rafael. We shouldn't be doing that. 5, we should close the Australian Defence and Trade Office in Jerusalem, an office established by the Department of Foreign Affairs and Trade to promote defence relationships with the State of Israel and trade generally, but particularly defence relationships. 6, we should withdraw all defence and trade officials from the Australian Embassy in Tel Aviv. 7, we should upgrade the Australian Representative Office to the Palestinian Authority to a full embassy to the State of Palestine. 8, in accordance with our obligations as a state party to the Rome Statute of the International Criminal Court, we should publicly affirm that Australia will enforce the arrest warrants against Netanyahu and Gallant and any others who may be subject of arrest warrants from the ICC. 9, we should impose further personal sanctions against individuals in political and military leadership roles relating to the violence on and since 7 October 2023 in both Gaza and the West Bank. 10, we should impose further personal sanctions against criminal Israeli settlers responsible for violence in the West Bank. 11, we should investigate, and where the evidence warrants it, prosecute Australian citizens who have served in the Israeli Defence Forces since 7 October 2023 for war crimes or the crimes against humanity or the crime of genocide as the evidence warrants. 12, we should prohibit Australian citizens from fighting in the armed forces of foreign states, any foreign states. 13, we should prohibit financial transactions with Israeli settlements and with Israeli organisations that support the establishment or maintenance of settlements. 14, we should end tax deductibility for any Australian charities that provide funding for Israeli settlements or for Israeli organisations that support the establishment and maintenance of settlements. 15, we should impose secondary sanctions on states that conduct arms trading with the State of Israel. 16, we should provide at least 15,000 humanitarian places for permanent settlement in Australia of Palestinian refugees from Gaza. 17, we should press the State of Israel to make reparations to the State of Palestine and individual Palestinians who have suffered as a result of the destruction of the Gaza Strip, and we should ourselves contribute to reconstruction efforts. 18, a small point but an important one, we should restore scholarship eligibility to enable Palestinians to undertake tertiary studies in Australia. That eligibility for tertiary scholarships for Palestinians was withdrawn from Palestinians in around 2021 or 2022, and I don't know why. 19, I promised you 20 points, but I'm only going to give you 18 of mine. I'm going to leave 2 for you. We are capable of creativity in this country. We just need to think a bit. So you've got 2 in my 20-point thought bubble to add yourselves to what this country can do. There's no justification for saying there's nothing we can do, or we're just a small state a long way away. I've heard that from Australian political leaders. It's a fig leaf to hide our inaction. It's a cop-out from our international legal obligations. And it's also patently untrue. There is much that we can do and that we should do. I focus my comments on the national government and on the situation in Gaza and more broadly in Palestine and Israel. But the same analysis applies to the obligations of state and territory governments. They are part of Australia. We have obligations collectively as a state, and they are part of the governmental system, the state system of this nation. And many of my 18 plus your 2 20-point thought bubble can be applied by the states as well. The state of New South Wales was also a co-sponsor of this arms exhibition 2 weeks ago, for example. And there are questions about procurement policy, especially of state police forces, that need to be examined more closely. So it is a national responsibility. If Australia is to be a good international system, we must promote, respect, implement and assist in enforcing international law at all levels and in relation to all situations. It's not a matter for me of politics or ethics. I'm not a politician. I'm not an ethicist. I'm a lawyer. And this is a matter of law and a matter of legal obligation. The Prime Minister announced when he went to the General Assembly in September that Australia was going to run for election to the Security Council. The question I have is, do we deserve it?
Thank you both very much. Some questions have already started to come in. Please continue adding them to the list. If anyone is having trouble using the QR code, we do have some facility to get a microphone out there, but I'll start with the ones that are coming through because we'll get through more that way. The first one, the first question, Chris, you touched on the issue of Australians who participate in the IDF. The question is, what are the legal consequences currently for individuals who choose to go and fight or give support to the IDF due to the provisional finding that Israel has committed genocide?
Individuals are responsible for their own acts, first and foremost. So let's deal with direct responsibility. If an Australian or anyone else has committed a war crime, a crime against humanity or genocide, or contributed directly to the commission of those crimes, that individual must be held accountable. Under our law and international law, we do not try people in absentia. They have to be within our jurisdiction. And so when an Australian citizen or even an Australian non-citizen is present in this country and there is evidence sufficient to warrant prosecution for one of those international crimes, the individual is liable to be prosecuted and should be prosecuted. Now, this is part of our obligation to punish violations of international law. And that obligation is considered so important in theory that it is incorporated into Australian law itself, the Commonwealth Crimes Act. So it's there. We recognise that we should be doing it whether a citizen or not. Secondly, is there a broader offence of complicity? That may be the case. It may be possible to argue that somebody who did not directly commit a war crime, for example, is complicit in the commission of the war crime. It's a harder legal test and it requires more evidence. It generally requires some active engagement in the act. So it's more difficult, but it is potentially a second area of criminal responsibility.
Next question. You touched on this as well, but does, and this is really for either of you, does Australia's recognition of the state of Palestine achieve anything, or does it change anything legally?
So the answer I always give when people talk about that, because it's very easy to be, I say this as someone who's taught international law for nearly 20 years, it's incredibly easy to be cynical about international law. And frankly, I wouldn't trust an international law who wasn't a little bit cynical about it too. But the line I always give, I said this in camera and I say it again, it's a very, very narrow hook to hang a coat on. But if it meant nothing, why did it send Netanyahu so insanely angry? If it meant nothing, why was there so much campaigning against it? Why were people so furious? And they were. So it's not devoid of meaning. It's not enough on its own. It won't mean enough until there are actual practical steps that follow, such as things like the establishment of an embassy, the establishment of bilateral treaty arrangements between the states, recognition of those kinds of standard agreements under international law that every nation state tends to engage in. So it does need follow-through, but of itself, it is something to really kind of start the clock and compel us to hold our elected officials accountable, to say, okay, well, you've done this. I'm sure you all thought it was a nice, shiny moment because everyone else was doing it at the time. Canada was and the UK was and France was. Back it up with something or be held accountable domestically. And that's where we have our power, which is that we, unlike, in international law, people feel cynical about that states can just engage in these kind of empty platitudes internationally and nothing happens. But domestically, it absolutely can. If it's a big enough issue, you vote the government out for failing to follow through.
I would just add the point, or 2 points. I'm sorry, it's 2 points again, not 20. The first point for me is about equality of treatment. For better or for worse, in 1947, the UN General Assembly passed a resolution, Resolution 181, that said that the British mandate on Palestine should be ended and that two states should exist side by side. A Jewish state and an Arab state was the description in the UN resolution, 1947. Now, that provides the legal basis, I think the only legal basis, for the existence of the State of Israel and also for the existence of the State of Palestine. Australia recognised the State of Israel in 1948. It's only, as you know, recognised the State of Palestine in September 2025. Now, it seems to me that this is a blatant example of unequal treatment in us acting on the consequences of 1947's resolution. And so, simply on the basis of equality, if we're to recognise the State of Israel, we should also recognise the State of Palestine. The second thing I would say about its importance is the effect on Palestinians. Emily's referred to the effect on Netanyahu, and I agree completely. The wonderful Navi Pillay was in Sydney 2 weeks ago. Navi was, as well as being a huge amount of things, the chair of our commission over the last 4 years. And when she was speaking in Sydney, she talked about the impact on her individually and non-white people in South Africa in the 1970s when Australians demonstrated against the Springbok tour. And the impact of her on her individually and other non-white South Africans to know that a country like Australia supported, recognised, identified with and supported them in their struggle against apartheid. And to me, that was very nice to hear her saying that. As I said, I'm really old. I was amongst the demonstrators in those days blowing whistles. But it was also to me a statement that applied to every other situation of gross human rights violations, of atrocities, Gaza and Myanmar and everywhere else, that the actions by people in other states that recognise and support have an enormous impact on the ability of people to survive and to continue their struggle. And recognition for me is part of that. It sent a message that was known by Palestinians and welcomed by them. In the same way that, in Sydney, the march across the Sydney Harbour Bridge was very well known to Gazans. Many of them referred to it and how much encouragement they got out of it. So let's not say that something is just symbolic, because symbolic can be very important to people.
So moving from the political back to the legal for a minute, Chris, you talked about the Commission of Inquiry's most recent report and its conclusions of genocide, but we also know there's an International Court of Justice case that is still pending as well. So for either of you, is a further finding by the ICJ about genocide in Gaza necessary? And if so, why?
I can be short. I think it is necessary. The ICJ is the most authoritative legal decision maker in the international system. I reckon we're pretty good as a commission, and we have produced in our report the most authoritative statement on this issue to date. And the only more authoritative one will come from the International Court of Justice, and it should come. The court may or may not agree with us, but either way, its decision will be the most authoritative that it is possible to get. And what has happened has been so serious that it warrants a decision from the most authoritative body.
Emily, anything further in terms of the sort of the power of state responsibility that comes out of ICJ?
Oh, look, just simply that states recognise it because most states in the world engage in the proceedings in the ICJ. There are very few who kind of bow out. They're aware of the importance of getting involved, such that we saw a very clear bit of legal manoeuvring done by the Ukrainians with regards to Russia as in relation to Russian claims of genocide in the eastern Donbass region. So I think there is a collective understanding among states that, yes, the ICJ is the kind of definitive statement. And so it is really important that there is that follow-up by the ICJ.
And the State of Israel has engaged with the ICJ proceedings, unlike with the International Criminal Court or even with the work that the Commission of Inquiry has done. Chris, there's a question here about if you could speak to a bit about the extent to which and how Israel has engaged, and has it made any submissions to the Commission of Inquiry?
No. From the day that the Commission was established, May 2021, Israel made it clear that it would not cooperate in any way with the Commission of Inquiry. That's not especially unusual. Most of these UN investigative bodies have no cooperation from the state under investigation. That was the case, for example, with Myanmar when we did that investigation, and that was under the NLD military coalition government. So it's not unusual, but they made that clear, and that's meant that we have not been able to visit Israel or Palestine. That's a significant issue in itself. The State of Israel has the right to exclude us from its own state. As a member of the UN, it shouldn't, but it has got the right to do it. But it has no right to exclude us from the State of Palestine. And we had invitations from the State of Palestine to visit. But because Israel controls all of the external borders, it refused to allow us to visit. And that's a breach of international law too. But I had to say that we're bloody-minded because we're not. But we regularly write to ask for information, to ask for visits and so forth. They made a mistake on one occasion and actually replied to the letter and said, as you know, we will not cooperate with you at all. But that was a terrible mistake by a junior official. They generally don't reply.
We have a couple of additional suggestions for your 20-point plan, Chris. We have point 19 proposed here, that Australia should facilitate the medical evacuation of critically injured Gazans and provide the specialist care needed to sustain their lives, as point 19. And point 20, we have a suggestion that Australia should also advocate for the safe and dignified return of displaced Palestinians to their homeland if they wish to do so. So more suggestions welcome for the remaining 2 points on the plan, but we've got some front runners.
Yeah, I'll take those,
Yep.
But I'm happy to extend it to a 30-point thought bubble. So please, keep them coming in.
We have another question here that I'll read out what's come in. What do you believe may be behind the Department of Defence's quiet restrictions on trade with Israel from the 3rd of November? And do you believe that UN reports, recent ICJ rulings and their implications are behind this, or are there other reasons entirely? I'm not aware of this, but I don't know if anybody else is.
No, nor am I. So I haven't haven't seen it. Maybe it was in response to the disclosure about that small contract with Elbit that was made in September, which was obviously very highly embarrassing. But I don't know what they've actually said they're doing, so leave that with me to follow up.
A further question. What else can Australia do to enhance the accountability of corporate entities for serious human rights violations?
I mean, the first stage in all of these things is always education, knowing what they're doing. It is no longer the case that when you go to the shops and buy something, it's been made by, the inverted commas mom and pop manufacturer who doesn't have connections. I mean, it only takes the tiniest little look to see these kind of global multinational corporations that own so many individual companies under them, and I don't imagine any single one of them is clean and tidy. So it does actually make it very hard to engage in boycotts. But to pick up on what Chris said about Navi Pillai and the boycotting of the South African Springbok tour, the boycotting of South Africa more generally in apartheid was hugely successful. Again, it took a very long time. But boycotts and public boycotts and making the company know that's why you're doing it goes a very long way. And then that has, extensions even further than that. So, I mean, an example would be obviously SodaStream that operates in the occupied Palestinian territories. You don't buy it. But more than that, you then boycott anything connected to it. Such, for instance, I think Scarlett Johansson did a ad campaign for them. Boycott her movies and make it be known that that's what you're doing. Again, it seems really minor and silly, but if enough people do it, it eventually gains traction. So in terms of what we as consumers, because this is what we up here, the only power we really have is boycotting, but making it be publicly known that that's what we're doing.
Thank you. We have some more questions coming in. So one question here is that given the low-tech capabilities of resistance movements, how can any, whether Hamas, Islamic Jihad or others, exercise a right to resist when under occupation by armed means without being accused of war crimes? Is that possible?
Well, I'll jump in. Emily will have views. It has to be possible. The level of technology doesn't make any difference to the obligation not to commit war crimes. Sorry. And nor does the context justify criminal activity. There is a context to what happened on the 7th of October, and that context was illegal Israeli occupation. And that entitled the Palestinian people to act to resist. The International Court of Justice has recognised that, let me say. But the resistance must be in accordance with the laws of war, international law. Although resistance is justified, resistance that violates international law is still a crime, regardless of the level of technology or anything else. And as I said, the firing of rockets into Israeli population centres is a war crime. And those responsible for it must be held accountable for it. So the question is not the level of technology. The question is whether or not the resistance is carried out in accordance with international law.
And look, I would just add to that there is, if anyone's interested, there are manifold examples of armed opposition groups who are fighting wars of national liberation, who make it part of their platform that they are going to be as compliant with international law as humanly possible, because they understand that it is not just a legal fight, it's a political fight as well, and that if they are going to have any success and be accepted on the international stage, they do need to play by the rules. Now, we can sit here and argue till cows come home about the legitimacy of the rules, and especially the legitimacy of an international legal system that was created by Western states and imposed on the rest of the planet. That's a whole separate conversation. It's a whole thesis, actually. But there are non-state groups around the world that intentionally engage with organisations like the International Committee of the Red Cross or with civil society organisations like Geneva Call to publicly vow that they are going to do things like divest themselves of landmines, because they want to be compliant with the Ottawa Convention that prohibits anti-personnel landmines, even though they are not bound by it, because they have not signed the treaty. But they do it because they know that there will be a lot of political traction that is gained if their enemy of the state, if their adversary of the state is breaking the rules and they are not. That's an incredibly powerful, persuasive tool that they have in their arsenal.
There's a question that's come in that that really relates more to the domestic context here, and there's been, of course, a lot of attention on the fact that there's been workplace bans of discussion around the situation, the genocide, and including within government entities. The question here is that, you know, somebody who's in that situation, is it lawful to prohibit that, and is there anything that international law maybe has to assist us in relation to this sort of situation?
Well, I'm not a labour lawyer, although I do. My best friend back in Sydney is. I could give her a quick call and ask her about it. But yeah, look, I mean, so the difficulty there is that it does. Again, Australia doesn't have a Bill of Rights, so we actually have very few legally protected human rights, such that we can say that they have been infringed by either the government imposing sanctions on its imposing rules on its employees, or by corporations imposing rules on its employees. So the difficulty there is it depends on the degree to which the few rights we do have in common law intersect with workplace, basically workplace relations and domestic labour law, which does have an obligation. I mean, corporations have an obligation to provide a safe environment for their employees, including increasingly things like psychosocial risk. I mean, yes, I can immediately hop off and call Shema Crystal and ask her on this, but for the moment, I can't actually speak with any degree of authority about to what degree that is an infringement on your rights in the workplace.
Similarly, I'm not expert in Australian labour law, but I know that Australian labour law does recognise the rights of workers in relation to broader aspects of their working lives. But I'd go back to international law, and particularly the human rights side of international law, where there are rights relating to freedom of expression, freedom of association, freedom of assembly. These are basic human rights, and I think that workers who are exercising those human rights in a workplace setting are still entitled to the protection of those human rights. Now, that does not imply a right, for example, to resort to violence or destruction, but certainly activity that is compliant with international law, in support of international law, seems to me to fall fair square within the ambit of international human rights law.
I can say that the Human Rights Law Centre will actually be putting out a short explainer very soon around workplace rights on the issue. So stay tuned to that, whoever asked the question. But while we're on the topic of kind of the workplace and the role of the labour movement, is there something particular that either of you can speak to about the role that the Australian union movement can play in the conflict?
Shall I go first this time? There is a clear role, and the Australian union movement for a very long time has a proud history of dealing with fundamental issues of human rights and social justice. And to go back, I raised before the South African example, and I raise it again. Australian trade unions were extremely active in the boycott campaign on South Africa and very much involved in the anti-apartheid struggle internationally. And the same also applies to an earlier stage of my life at the time of the Vietnam War and the anti-conscription campaigns. So these are not new issues for Australian unions, and they're as relevant in the case of Palestine as they are in any other situation the union has taken up. And I know that there are a number of unions individually that have been active on these issues, and a number of regional councils of unions. The ACTU itself has adopted resolutions, but To give you one example, in my home state, the New South Wales South Coast Labor Council, based in Wollongong, south of Sydney, has been very active on this. And they're particularly looking at local industry, the steel industry, as to whether there are steel exports to Israel, and if so, what the impact of steel exports is. And certainly, if there is a risk, possibility even, of Australian manufactured steel being used in the manufacture of Israeli tanks, there is a very real issue of international law. So the Labor Council has been doing the hard work through its affiliates of looking at what local production, whether local production is contributing in any way to the state of Israel and its war effort. And I think that's a good example of a direct responsibility of trade unions. But there's also the broader area the examples that I've given where unions in the past have taken up issues of human rights and social justice.
Yeah, thanks, Chris. And East Timor was another big example of where the union movement played a huge role. We have some more suggestions that have come in for the 20-point, now 30-point plan. And so maybe I'll read a couple of those and see if there's comments or thoughts from either of you on those. Starting with, a very significant one, but it's around demanding SBS oppose Israel's entry in Eurovision. And I think there might be a petition outside in relation to that one, or committing to withdraw if the EBU does not disqualify them. But then there's also the suggestion that Australia could actually commit Australian troops and defence personnel and human rights observers as well on the ground as part of an international peacekeeping commitment now that the Security Council has endorsed parts of the plan for a stabilisation force.
I don't know what, if any, role we have in who participates in Eurovision, but in terms of the desirability of Israel being prohibited, well, again, I just point to the South African campaign and the significance of exclusion of South African representatives from the Olympics and even for many years suspended from the General Assembly. So, again, there are precedents. The second question again, I was going to...
Around Australia committing
yes.
Troops as well as human rights observers.
I can't even answer the question of this international stabilisation force because God alone knows what it is. I don't know if anybody else does. And we certainly should not be committing anything to it until we have a hell of a lot more information. One of the problems with the Security Council resolution, as I implied, it's very fine on the thought bubble, but it's not too good on detail. So we need to know more. But human rights monitors, the human rights monitors are always a great idea, but I don't know whether the state of Israel would allow them in.
Yes, the problem with the stabilisation force is it's been incredibly wishy-washy on any kind of timeline for proper establishment of a state of Palestine. In fact, the terminology has even walked back even further than that, which just talks about the possibility of eventually establishing the state, which is some incredibly equivocal language. I don't think you would want to commit to any official recognition, of the level of sending troops.
And of course, the thought bubble doesn't mention accountability in any form.
And it does. It does. It mentions one area of accountability, and that is an amnesty for Hamas fighters who have committed war crimes. Isn't that interesting? This was meant as an inducement to get them to leave Gaza, but it's strange that the only issue of accountability mentioned in the 20 points provides an amnesty for potential war criminals and Hamas war criminals.
So beyond that, the lack of recognition for accountability, there's a question here around what role do you see organisations having, including the Hind Rijab Foundation, in supporting the application of international law in prosecuting individuals who have committed war crimes?
Well, the advantage of... sorry, I was in trouble 2 words into that sentence. The advantage of the law with regards to war crimes, crimes against humanity and genocide is that it attaches to universal jurisdiction. which means it's prosecutable by any state anywhere in the world, regardless of a connection to the offences at issue. So if a state finds on its territory someone who is alleged to have committed war crimes, crimes against humanity or genocide, they are under an obligation to prosecute. So that means that there is scope for any state in the world to bring proceedings, so that you don't need to worry about making some kind of territorial or personal jurisdictional connection. So there really should be a very systematic effort on behalf of state governments around the world, and I say capital S state as in sovereign state governments around the world, to open investigations where they believe that there might be a connection. So increasingly we've seen that in relation to governments like the UK, I believe Germany and France as well as Australia, opening standing prosecutorial bodies to look at the commission of war crimes by their own members of the armed forces. And those kinds of bodies should expand to include any possible connection to anyone found on their territory that could be made to war crimes that have been committed, and again, not just in Gaza, in Sudan, in Myanmar, basically anywhere that they are currently taking place.
Coming back then to Australian, to the focus of Australia's role, there's a question here about whether or not under current international law there's any basis for holding senior Australian officials, whether the Prime Minister, the Foreign Minister, the Defence Minister, for supporting or being complicit in genocide.
Easy answer, legally, no. It's too remote. Because you would have to, genocide is hard to prove even when the causation is very, very clear. It's much harder to prove when you are getting that kind of further and further away. And the biggest stumbling point would be the intent element. You would have to prove that if, you have to get over the first hurdle of that Penny Wong, Anthony Albanese, whoever you wanted to put on this kind of proposed list, that not only did they engage in an act that meets the standard of genocide, which is measures in place to prevent bursts within the group, forcibly transferring, murder, other kinds of mistreatment and acts that are covered under the Genocide Convention, but you would have to also prove that they had the intent to do so. And I think that would be unbelievably hard to prove. Part of what has been horrifyingly demonstrated, but has been that the Netanyahu government has had officials who've just straight out come out and talked about, we absolutely want to eliminate Palestinians in Gaza, which has made the purpose of proving the intent much easier. But in the absence of statements of that nature, it would be unbelievably hard to prove that any Australian political leader got over that mens rea element.
I concur with my learned friend.
Maybe back to you, Chris. Why do you think that the Australian government doesn't feel more motivated to do more, to be compliant with international law and hold Israel to account?
Look, I can only conjecture the same as all of you can. I don't know. It certainly is not a high priority. That's evident from the time taken to recognise the ALP National Conference in 2017, I think, adopted a policy of recognition of the State of Palestine and said that this should be a high priority for the government, and it took 4.5 years. So if that's a high priority, but I don't know why. Maybe
coming back to you, Emily, there's a couple of questions here around the sort of responsibilities to divest from corporate connections with crimes being committed, both in terms of the investments by Australian superannuation companies, as well as university institutions, and how can they be held accountable, particularly for investing in weapons companies that have direct connections to the situation in Gaza, including, for example, ANU's investment in Elbit shares.
Yeah, so I mean, I'm fortunate that the University of Sydney has recently, in response to the encampment that was on Sydney University grounds for several months, that in response to that, the university administration did go through a reasonably comprehensive analysis of all of the investments the university was making. And even though there were some missteps in the aftermath of what took place by the Central University, one of the things they did do was make a commitment and then did follow through on divesting with weapons manufacturers who were selling to Israel. That's happened comparatively recently. But I think there is an obligation upon nearly every university in Australia is publicly funded, takes public money. I think there is an obligation on employees of the university, of students who are enrolled in universities, and of people who otherwise have connections to universities to pressure their central administration to make those kinds of commitments. We've seen it happen in response to advocacy that was being done by academics and students. There was divestment from investing in firms that are directly contributing to climate change. So it's just about applying those to current situations and really pushing the university administration to follow through.
We have a few other suggestions for the list, which I'll touch on because we're almost out of time. But there's some suggestions around proscribing the IDF as terrorists, or also proscribing senior Israeli officials in the same way. That Australia could potentially do that. Also stopping intelligence being transmitted from Pine Gap. And to not only Israel but also to the US and other states that are complicit, or better still, shut it down, is the comment here. There's also sort of suggestions around the role that Australia could play in advocating publicly, as well as in diplomatic channels, for the release of Palestinian activists and political leaders, including Marwan Barghouti. So there's suggestions there, and of course there's also sanctions that have been issued by the US against Palestinian human rights in organisations for collecting evidence and providing it to investigators, like the Commission of Inquiry as well as the ICC. So any thoughts or comments on any of those?
Keep them rolling in. Not only the Israeli detention of Palestinian activists, a very large number, or perhaps probably most, of the Palestinians who are in detention are just ordinary people against whom there appears to be no evidence at all. Certainly not any evidence that the Israeli authorities are prepared to have examined by an open, fair court process. So it's Palestinian detainees in general that's the issue. And the reference to Marwan Barghouti is an interesting one. I think I don't know what Marwan Barghouti is going to be like. I've got no idea. I've never met the bloke. It's probably more hopeful than based on solid knowledge when he gets described as Palestine's Nelson Mandela. Who knows? Who knows after 20-something years in prison what the state of his mind is or anything else. But the fact that he has not been released indicates the Israeli authorities are genuinely scared of his ability to unite Palestinians. So I would say that, for me, that's a litmus test of whether the Israeli government is serious about peace. And when Barghouti is released, we will know that maybe there's a good chance that they're interested in peace talks. Until he's released, well, we know that they're continuing to do everything possible to prevent the unity of the Palestinian people. I'd say to that. Look, just a quick comment on terrorism. I stay away from that. There is no international definition of terrorism, and so I just don't go into it. We, as a commission, we have not described ever Hamas as a terrorist organisation, nor have we described the IDF as a terrorist organisation, because there's no definition. Ben Saul, who's the Special Rapporteur on Human Rights and Counter-Terrorism, another Australian, is writing his next report. He told me yesterday on an attempt to define terrorism for international law purposes. We rely on international law. We apply the law, as I said, in relation to genocide, but there's no law that really adequately deals with terrorism, so we stay away from it.
We are pretty much up to our time, but there's a few questions that again all relate to kind of the responsibility under international law of some different actors. So maybe I'll go through those and then open it up to either of you to touch upon. That includes the responsibility under international law to be personally or criminally liable in relation to the directors of arms manufacturers. So that's the first category. The second relates to the responsibility of the media and including social media influencers who may have been involved or endorsing acts that are being subsequently characterised as international crimes. And there was one more. Maybe we'll start with those two first.
Well, part of the crime of genocide includes the crime of incitement to genocide. So in the International Criminal Tribunal for Rwanda, there was a famous case where basically a DJ, a person who was on the radio, was prosecuted. It was called the media case, where they were prosecuted for their incitement to genocide by the fact that they essentially, went on the radio and spoke in derogatory terms, and encouraged people to go out and annihilate the Hutus. So there is some scope, but again, it has to get to that level. It has to get to that level of incitement in order to be able to hold someone accountable. For the directors of corporations for weapons manufacturers, again, it would have to get to the level of that they are either manufacturing manifestly illegal weapons, so chemical weapons, biological weapons, nuclear weapons, depending on whether the state is party to the Nuclear Weapons Prohibition Treaty, or any other weapon that is fundamentally of a nature to cause unnecessary suffering or superfluous injury, because that's the legal test for whether a weapon is banned or not, or unless there was something connected to public statements that, again, were incitement to commit war crimes, crimes against humanity, or genocide. But there currently isn't the crime of incitement to war crimes in the same way as there is incitement to genocide.
And the last one is, and maybe back to you, Chris, in terms of whether or not this is something that the Commission has got to look at so far. But the expulsion of released Palestinian prisoners by Israel to third countries. What does international law have to say about that? That you can think about.
Yeah, international law says you can't do it. But they can be expelled from the state of Israel because they're not Israeli nationals. But they can't be expelled from the state of Palestine. And it is considered a war crime. Forced displacement is what it's called. And that's the area that's looked at, for example, in relation to the expulsion of the Rohingya from Rakhine State in Myanmar. So that is a war crime. It's a constituent element of a crime against humanity. So it's not allowed. They need to be, they can be deported from Israel, but they can only be deported to Gaza or the West Bank, that is the state of Palestine, without their consent.
Do either of you have any other last things that you haven't got to say, or any other new thoughts for the remaining points on the 30-point plan?
Don't give up. Don't give up. Don't give in to despair, as easy as it is, because it is, we are living in despairing times. But just keep up the fight. Tag out for a while if it's getting too much, but keep fighting.
You didn't say what I expected you to say. 50 years ago, maintain your rage. The same thing. Oh, you're too young, Emily. Look, the last thing I would say is just go back to what Emily's spoken about, my opening comments. International law is really important. The development of this law goes back for a long time, but the explosion of international law is since World War II, 80 years. And in the course of 80 years, an enormously beneficial and comprehensive body of law has been developed. The development of the law has not been accompanied by a similar rate of development of systems, mechanisms for implementation and enforcement. That's the weakness. But it is getting better. And yet we find ourselves in a turning point where all that has been accomplished can be undone. Now, I really, and I don't think it's just a complaint from an old man, I really feel that all that has been built in the last 80 years is under existential threat. It may not survive the current global situation. And so if nothing else, yes, we'll take away from tonight and similar nights better understanding of the situation in Gaza and West Bank. But generally, if nothing else at the general level, let's go away with a determination that what has been built will be maintained and furthered and not nipped in the bud.
Well, I think at a time when international law is under such threat, having this many people turn up to recommit to the importance of those legal frameworks as a tool that we have is more important than ever. So I want to thank everybody for being here. Thanks again to the organisers, and maybe if everyone can join me in another round of thanks to our speakers.